Let's begin. So welcome everybody to the VMM Northwell Health LGBTQ Health and Life Planning webinar series. This is an ongoing series and this is our last webinar during Pride Month. Happy Pride for everybody. We have done them the past 3 Thursdays. We're not doing one next Thursday because Joe Milizio, who will be speaking today, is being honored by Cranes as a notable LGBTQ leader and executive for his contribution to the field. So we're all very excited for him. We are going to have 2 attorneys speaking today. Joe Milizio, who is the managing partner of VMM and heads our LGBTQ representation practice, as well as our surrogacy, adoption, and assisted reproduction practice. Paid surrogacy became legal in New York this February, and VMM is at the forefront of that. To the best of our knowledge, we are the only law firm in New York that handles surrogacy, adoption, assisted reproduction, as well as estate planning in one place. Also speaking today will be Joe Trotti. Hi, Joe.
Hey guys, how are you?
VMM Family Institute, which is our multiple award-winning matrimonial and family law practice. And I will let Joe introduce Dr. Goldman.
Unfortunately, Roy, I do not have Dr. Goldman's credentials in front of me.
Indeed a scandal.
I can make it up, but
Dr. Randi
I'm sure
Heather
it wouldn't
Goldman,
be nearly as sophisticated.
Right. Dr. Goldman is a OBGYN at Northwell Health. She is also an assistant professor at the Donald and Barbara Zucker School of Medicine at Hofstra Northwell. She is affiliated with Long Island Jewish Medical Hospital, North Shore University Hospital, and the Katz Institute for Women's Health. And she is a specialist in reproductive medicine and infertility treatments, if I'm getting that correct. Is that correct, Dr. Bowman?
That is all correct. Thank you.
Wonderful. Off the top of my head, I didn't read this from anything.
Yes, no, thank you so much.
And she's a lovely person, if I might add.
And her husband just probably passed the 3rd round of interviews for Jeopardy, so he may win Jeopardy.
Yes, thank you very much for that very kind introduction. So yes, I'm a reproductive endocrinology and infertility physician here in New York at Northwell. I did my training at Brigham and Women's Hospital and Harvard Medical School for both my residency training at MGH as well, and for fellowship I also stayed at Harvard. So I'm very happy to be here where I've been for the last 3 years treating couples and individuals with fertility needs. So thank you very much for having me. All right.
So Joe Milizio, we have 2 Joes, and we call them the Joes. So Joe Milizio, would you like to start off?
Sure. Well, maybe I'll give a little forward on the new law, and then Dr. Goldman can go right into her work, and then Joe Trotti and I will follow up sort of as the legal disclaimer at the end of a commercial, and give all of the pertinent legal facts with respect to the surrogacy law. So the new surrogacy law in New York is called the Child Parent Security Act, and it was enacted in April of 2020, but became effective on February 15th of this year. And New York was one of 3 states, together with Louisiana and Michigan, that specifically outlawed surrogacy programs or surrogacy in and to itself for more than 30 years. And the reason for that was the courts and the legislature were very concerned that people were going to become engaged in, for lack of a better term, baby selling. And perhaps more importantly, or as equally important, was the fact that they thought that surrogacy arrangements could have severe negative consequences with respect to the surrogate herself and with respect to the physical and emotional health of the surrogate and potentially the intended parents if something didn't go the right way in accordance with the surrogacy proposal. So they were concerned about the exploitation of women, and in 1992, they banned surrogacy in New York. And that was most likely a result of a case in New Jersey from 1988, which was known as the matter of Baby M. The matter of Baby M, for those of us who are a little bit older, let's say, will probably be recognized as the Mary Beth Whitehead case. And that case involved a intended parent, a gentleman in New York, who hired a surrogate to be inseminated with his sperm, and it was her egg that was utilized in the process, and she carried the child with an agreement that she would give the child up at birth. Now, because she was married, her husband also was a party to the agreement, consented to the surrogacy arrangement, and everything went along smoothly until the birth. After the birth of the child, both the surrogate and her husband absconded with the baby and refused to turn over the baby to the intended father, and it became a court case. And the court ruled that a surrogate who was actually the genetic mother of the child had the same rights as the intended father, even though the intended father and the surrogate had an agreement that specifically stated that the intended father would be entitled to father and raise the child. The court stated that the intended father, however, as a biological parent also, was deemed more fit than the surrogate biological mother. So the outcome of the case was very positive as far as the father is concerned, because it basically, the court basically allowed the father to maintain custody of the child, to parent the child, but the surrogate did have visitation rights. And I don't know what the arrangement is today. The child would be over 30 years old, so it will be interesting to know that. But in any event, the surrogacy arrangement in New York was outlawed, and over time, various states entered into surrogacy arrangements and statutory provisions allowing surrogacy, some a lot more lenient than others, but nevertheless, people were going outside of New York to arrange their surrogacies, because in New York, if somebody facilitated a surrogacy, it could be a $10,000 fine on the first offense, and we're really referring to attorneys here and healthcare providers. And on the second offense, it was deemed a felony, which would mean both of those professionals could or would lose their license to practice. So attorneys were not familiar at all in New York with surrogacy arrangements up until this year. So it's a relatively new jurisdiction for us to enter into, despite the fact that surrogacy is a very popular program for the LGBT community, as well as obviously the straight community and single parents or single intended parents, etc. But New York, in saying, okay, we're going to allow surrogacy, but we're still sort of hesitant with it, came up with various protections in their surrogacy law, which Joe and I will get into after Dr. Goldman tells us about what she does. And you're on mute.
Yes, can everybody hear me? Okay, perfect. Thank you. So I have a little presentation, and we're going to talk all about fertility, and hopefully you guys are going to be able to see my screen in just a second. All right. Are we good? Perfect. Okay. Move this out of the way. All right, perfect. So the things that I want to talk about today are to discuss the options for fertility treatment for individuals and couples that don't have a sperm producing partner, talk about the fertility options for individuals and couples that don't have an egg producing partner, to briefly talk about the impact of gender affirming treatments on reproductive potential for the trans community, and then also to explore some fertility preservation options. So first, what are sperm, what are eggs? This is really the crux of what's needed to make a baby. So sperm cells and egg cells contain a person's DNA, and both sperm and egg are required to make an embryo. So when sperm and egg combine, they create an embryo, which can then grow into a baby in a person's uterus. And typically, people who have an X and a Y chromosome produce sperm, and people that have two X chromosomes produce eggs. So both of those are required. If there is lack of egg or sperm, then oftentimes we use what's called third-party reproduction. And third-party reproduction is the use of eggs, use of sperm, or use of embryos that have been donated by a third person or a donor that will enable an individual or a couple that are called the intended parents or the recipients to become parents. And this also encompasses the use of a gestational carrier to carry a pregnancy. So for individuals or couples that don't have a sperm producing partner, commonly this is like a cisgender lesbian couple. And the options for family building include lots of things, but we're going to focus on IUI, or intrauterine insemination with sperm donation, or IVF with sperm donation. And this also includes something called reciprocal IVF, which we'll talk about. So with intrauterine insemination, that occurs when you have sperm that's from a donor that can either be a known donor or an anonymous donor that is washed and put directly into a person's uterus at the correct time of the menstrual cycle. This is what we would typically do in a fertility clinic, although there are people that use either a known or anonymous sperm donors at home. Like I said, the sperm can be directed, which is where it's a known person, or it can be anonymous, which is usually from a sperm bank. In a fertility clinic, both directed sperm donors and anonymous sperm donors undergo or have undergone screening, like infectious disease screening and genetic screening, to ensure both safety and genetic compatibility. With an IUI cycle, usually this is combined with medications that can help somebody ovulate or potentially ovulate more than one egg at a given time. And the IUI itself is a speculum exam where the sperm that's washed is put directly into the uterine cavity, and it's sort of like what it looks like in this picture over here. IVF is a little bit different and a little bit more involved. The IVF process occurs when eggs are removed from the body and fertilized with sperm outside the body in an IVF lab to make an embryo. That embryo is then transferred back into the uterus to try to establish a pregnancy. Treatment with IVF can be either recommended if intrauterine inseminations, say, are unsuccessful at achieving a pregnancy, or with something called reciprocal IVF. And reciprocal IVF is when one partner's egg and donor sperm is put together to make an embryo, and then that embryo is transferred back into the other partner's uterus. And so in this way, one partner contributes the genetic material, the egg, and the other partner carries the pregnancy. So it's a really great option. IVF is a little bit more involved than IUI and involves taking medications that are given by injection for about 10 to 14 days. All these injections are with really small needles that go into the belly, just like in that picture there. And during the course of those about 10 days, a person comes in for blood work and ultrasounds quite frequently for monitoring to see how they're responding to the medications, count the number of follicles, and see what sizes they are. A follicle is basically what houses the egg. The follicles are in the ovaries, and we expect that there's an egg in each of those follicles. Once those 10 days approximately are over, then there is a final shot that's given that's called the trigger shot. And that's the last injection that you take during an IVF cycle, and that stimulates ovulation and stimulates the eggs to mature. About a day and a half later, 36 hours on average, an egg retrieval is done, all in the IVF office. And during the time of the egg retrieval, a person is asleep under anesthesia, but breathing on their own. And the whole thing takes about 5 to 15 minutes, depending on how many eggs there are. You find out that day, right before you leave, how many eggs were retrieved. And the stay in the recovery room is about an hour before going home. So this is kind of what it looks like when we're doing an egg retrieval. There's a transvaginal ultrasound probe that goes in and has a little needle attached while you're asleep that removes the eggs from those ovaries. The eggs go into a test tube and it's handed off through a window to the embryologists who are waiting for it. And they actually count the eggs in real time so that we know how we're doing throughout the case. That day, the eggs and the sperm are put together in the lab, and hopefully fertilization happens. And if fertilization is successful, that's when we know that we have an embryo. That embryo is then allowed to grow in the lab for somewhere between 3 and 6 days, and then an embryo transfer occurs. There is always the option of doing genetic testing of those embryos as well, but either before or after the genetic testing, the embryo transfer happens. So the embryo transfer is not done under anesthesia. It's done in the same place as the egg retrieval, but it's similar to a pap smear, where a little catheter goes in and deposits that embryo directly into the uterus under ultrasound guidance, so we know we're getting it in the right place. And then a pregnancy test is done about 2 weeks later, and we hope for a positive result. So is there insurance coverage for any of this, for IUI, for IVF? The answer is it depends. It's variable. There are some insurance companies that cover both IUI and IVF. There are some insurance companies that require proof of a diagnosis of infertility, which can be challenging. So if you have a couple where there's no sperm producing partner, I would argue that is infertility due to lack of sperm, but not every insurance company agrees with me. And so sometimes they might require self-pay for IUIs for a couple months, and if it doesn't work, then they might cover additional treatment. Next, we're going to talk about fertility options for individuals and couples that do not have an egg-producing partner. And a common example of this is a cisgender male couple. So typically, there's no uterus and there's no egg-producing reproductive organs. And so for this example, or for a single male, IVF with egg donation and a gestational carrier is an option. So egg donation, like sperm donation, can either be directed, which is with a known donor, or anonymous, like an egg bank, just like there are sperm banks. So similar to sperm donation, egg donors also need to undergo or have undergone infectious disease screening and genetic screening for compatibility. Directed donors would undergo an IVF cycle to retrieve eggs just in the same way that we spoke about before. And then those eggs are fertilized with sperm from one of the intended parents. Eggs from a bank would be transferred to a fertility clinic, thawed, and combined with sperm from an intended parent to make an embryo. And then that embryo would be transferred into a gestational carrier. And like we heard about before, gestational carrier is now an option in New York State. So this might be a little bit of a review, but a surrogate is a person who agrees in advance to carry a pregnancy with the intent to relinquish custody of the resulting child to another person or people after birth. And so there are 2 types of surrogates. One is the traditional surrogate, like we heard about in the case, where one person provides both the egg and also the uterus. So provides the egg for the genetics and carries the pregnancy. And this is not something that we typically do because of the very complex issues with providing both the egg and carrying the pregnancy. What we really do now is to use what's called a gestational carrier, where they're not providing any genetic link to the child, but they are volunteering to carry the pregnancy using their uterus. Gestational carriers can be commercial, those are compensated carriers, or altruistic, which are uncompensated donors, oftentimes a family member or a friend. So knowing this, there are a lot of potential people that are involved with having a baby, with third-party reproduction in particular. So you've got, the intended parents, 1 or 2, a gestational carrier and maybe their partner, an egg donor, maybe their partner, a sperm donor, and maybe their partner. So it could be 8 people that are involved in having a baby. And so all of this requires very complex medical and legal decision making. And so it's really important that, if you're going to embark on something like this, to have really good connections with both a medical and legal team. So gestational carriers from a medical standpoint undergo screening. They need to meet eligibility requirements before they're able to be a gestational carrier. This includes both medical evaluation and psychological evaluation, as well as things like infectious disease screening. The psychosocial evaluation is important for everybody involved: intended parents, gestational carriers, and oftentimes their family members too. And it's very important to make sure that anybody that is volunteering to be a gestational carrier is able to provide informed consent and is free for any type of coercion, whether that's financial coercion or otherwise. So next we're going to switch gears a little bit, and we're going to talk about gender-affirming treatments on reproductive potential. So people who are transgender have the same reproductive desires as people who are cisgender. But gender-affirming treatments like hormones or surgery can potentially impact fertility potential. So in light of this, all transgender individuals, regardless of age, should be counseled regarding their fertility and family planning before they initiate treatment, ideally. And this is very much supported by the Endocrine Society, as well as our governing body, which is called the American Society for Reproductive Medicine. It's important to talk about fertility preservation before treatment begins, because stopping treatment to pursue fertility preservation later on can be quite challenging emotionally. So for transgender women, they're often on medications like androgen blockers and estrogen treatment that can decrease sperm counts over time. But it's important to know that this is not considered contraception. So sperm counts can be lower, but it can still get somebody pregnant. So stopping medications are generally reversible, have a reversible impact on fertility over about 3 to 6 months. But there's very little evidence regarding when and to what degree sperm production will resume after treatment is discontinued. Prolonged estrogen may cause testicular damage, and some people do experience permanent infertility, although that's quite rare. Other medications like androgen blocking medications like spironolactone are very common. They can cause birth defects if taken during a pregnancy, and so in general should be discontinued. Some people need oral or injection medications to improve sperm production in order to achieve a pregnancy as well. An orchiectomy, or removing the testes, also called a gonadectomy, can result in permanent loss of fertility. And so sperm cryopreservation is an option. If a patient thinks that they might desire a biological child one day, freezing sperm before treatment initiation is something that should be considered. Cryopreserved samples, in theory, should remain viable indefinitely. Now, transgender women as a gestational parent is interesting. This is involving uterine transplantation, and uterine transplantation is still in its infancy. So there have been viable and healthy pregnancies that have been born to cisgender women who have had a uterine transplant, but this whole process is still considered experimental. And surgeries have not yet been done in transgender women, but it might represent a future fertility treatment option for transgender women who wish to carry a pregnancy, but at this point it's still too new to know for sure. Now for transgender men, the long-term effects of testosterone on ovarian function and fertility are very much unknown. Testosterone levels that are in the male range typically suppress menstruation and ovulation, but people can still ovulate, and so it's also not considered contraception. Testosterone can also cause birth defects if taken during a pregnancy. So most transgender men who discontinue hormone treatment will have resumption of periods, and about 80% will start menstruating within about 6 months of discontinuing treatment. We do know, and you see it in the media, that transgender men have spontaneous conceptions, and it probably is all the time after stopping testosterone, but it's unknown if everybody is going to be able to do that. Thankfully, there's no evidence that people who previously took testosterone have any sort of increased risk of pregnancy complications. But the ideal testosterone washout period, if any, is largely unknown. And it's also unknown whether discontinuing testosterone will routinely allow for return of periods or for carrying a pregnancy. Thankfully, more recent studies have suggested that testosterone has no negative impact on egg quality, which is really reassuring. Removing the ovaries, also called an oophorectomy or a gonadectomy, will result in permanent loss of fertility. And similarly, removing the uterus or a hysterectomy will result in the inability to carry a pregnancy in the future. So in light of all of that, we're going to end by talking about some fertility preservation options. So egg freezing is one of the most common ways that we preserve fertility. With egg freezing, we remove eggs from the ovaries and we freeze them prior to the initiation of surgery or hormones, including pubertal blockers as well, androgen surgery, etc. Those eggs that are frozen can then be used in the future if desired with a partner, with a gestational carrier, and it just really provides another aspect of reproductive freedom and reproductive choice. And egg freezing is something that we do all the time, both for planned reasons to try to prevent sort of the age-related loss of fertility for a cisgender woman. So it's something that we do all the time. So like we said, what an egg is, it's also called an oocyte. They contain the DNA, and when combined with sperm have the potential to become an embryo that grows into a fetus and a baby. Eggs are fascinating. They are the largest cell in the body. They're actually visible to the naked eye, and they're about the diameter of a human hair, about 110 microns. So they're still really tiny, and you can see them best with a microscope, but they are the largest cell with the highest water content and are found in the ovaries. So the egg freezing process is very similar to the first part of an IVF cycle with the stimulation medications and the about 10 days of monitoring. So if somebody is interested in egg freezing, then we will do an initial consultation, a review of medical history, usually do a physical exam as well as some labs. For a transgender man, ultrasounds can often be done transabdominally because pelvic exams can be quite uncomfortable and testosterone can cause vaginal atrophy. So while the egg retrieval itself is done vaginally while somebody is asleep, the monitoring process can be done with abdominal ultrasounds. After an egg retrieval, the eggs are retrieved and frozen that same day with a process that's called vitrification. And with vitrification, the eggs are frozen in kind of a glass-like state. As far as we know, there is no shelf life for eggs that are frozen, and they can be used at any point in the future. Important to know that anytime somebody has an egg retrieval, that a period will occur about 2 weeks later. So the success rates are very, very good, but there's unfortunately no guarantee with any of it. So there's no amount of sperm frozen or no number of eggs frozen that can guarantee a live birth in the future, but it is definitely something that can help increase the likelihood of having a biologic child in the future, knowing that there's a million ways to build a family. The cost of egg freezing is variable. Some insurance companies cover egg freezing and some insurances don't cover egg freezing. We consider egg freezing before starting medication or a surgery to be medically indicated, which does decrease the cost a little bit, but it still can be expensive if insurance doesn't cover any of it. Now, what about adolescents? So transgender youth can also undergo egg freezing if they've started to undergo puberty. Pubertal suppression with GnRH agonists like Supprelin or Lupron are usually reversible. With discontinuation of a pubertal blocker, the pubertal processes will resume, but most adolescents who use pubertal blockers will then go on to use gender-affirming therapy thereafter. And so for transgender adolescents, oftentimes we consider egg freezing before initiation of any treatment at all. In light of this, the ideal timing for egg freezing is largely unknown. In the future, we might be able to freeze ovarian tissue. So this is no longer experimental as of 2019, but most data for ovarian tissue freezing is from the cancer population. With ovarian tissue freezing, it involves a surgery, like a laparoscopy or a laparotomy, to remove either an ovary or part of the ovary and freeze it. And inside that ovary is follicles. And so we hope that we could remove those follicles, get eggs out, and potentially improve reproductive rates in that way. With ovarian tissue freezing, there have been about 150 births overall when you put that tissue back into the body, but there's not really data for the trans population with this technology. And like we talked about before, hopefully uterine transplant in the future will be an option as well. So in conclusion, there are many, many ways to build a family. And there's options for family building that involve both biological children, adoptive children, and truly any way to build a family is a good one. It's important to talk about family planning, talk about fertility for all patients, regardless of sex, gender, preferences, etc. Third-party reproduction is often utilized for the LGBTQ community, individuals and couples, as well as single people. And the impact of long-term exposure for people that are on gender-affirming hormones, either on eggs or on sperm, is unknown. But so far, the data is very reassuring. And as we learn more and more, the data has only been reassuring to this point. There are some treatments that might lead to irreversible infertility, commonly things like surgery. And fertility preservation before treatment can be accomplished with things like egg freezing or sperm freezing. And thankfully, options for fertility preservation and treatments are expanding. So I very much appreciate the opportunity to talk today. We are always happy to see anybody. This is our number, or it's 516-562-BABY. It's very easy to remember. And I see patients at Northwell Health Fertility on Long Island. Thank you. Oh, I think that you're muted.
Yeah, no, thank you, Dr. Goldman. That was thorough. We already have a few questions in the chat, but we'll leave them to the Q&A at the end where we can answer comprehensively. I would like to welcome Joe Trotti, the head of VMM's matrimonial and family law practice, to talk about things from that perspective.
So as Roy mentioned, I had the family law practice here at District McGovern Milizio. And what I'm going to talk about just for a few minutes is basically obtaining this order or this judgment of parentage, or in some cases, a pre-birth order of parentage, and the mechanics of getting that done. So the first question is where to file, where to get this order. And when the statute came out, and reading the statute, it basically indicated that you can file in one of three courts, either the family court, the Supreme Court, or the surrogate court. You can file in any one of the three. After that law came out, in dealing with the courts and health departments and various professionals and officials in this area, we basically were advised that family court would be the place to file the petition. Against that, certain courts have gone in different ways, and certain counties have enforced it in the way that they wanted. We're always trying to get information for our clients on where to file. And literally 2 minutes before we came on, one of our surrogacy expert associates in this office, Meredith Chesler, literally came in with an email from Kings County indicating that Kings County will accept the petitions in all three courts. We were also speaking to a Queens family judge and a Queens Supreme Court judge. And there in Supreme Queens, the Supreme Court judge said that she was going to be handling all of these pre-birth orders of parentage. And so it could be that in a particular county, there is a dedicated part, or there is a dedicated court that's going to handle the application. And so what's my take on all of this? Generally, find out in a particular county where you're going to file, which court is more familiar with the process. And the reason I say that is because if they're more familiar, it will generally pull up less roadblocks, fewer roadblocks, so that you'll be able to get this order because they're used to handling this type of application. My feeling is that since it's a new law and it's a new statute, that by the end of the year, everyone will know in the particular county that you're applying, which is the correct court. And so what are you doing? Like, what are we filing here? What are we talking about? We're talking about filing a petition. It's a petition that will get the order or the judgment that you require. And I'm a proponent of generally making these elaborate petitions with as much information as possible to give to a court so that it doesn't have just the standard form in front of it to deal with. However, this is a new law and it's a new statute. And now that the family court has issued model petitions for all of us to use, I highly recommend that we use them. And why do I recommend that? Because since it's a new law and a new statute, judges, the courts, they're going to be very careful in that everything is checked off, that jurisdiction is obtained, and that they can issue the order in the proper form. They're going to be worried that something is missed, and they'll double check if you don't follow the form or use the form. If you use your own form, for example, they're going to double check that form to make sure that everything is there, leading to more scrutiny. The family court has issued forms. We can get them. It's through the family court. Everyone can access them. And so I highly recommend that you use them. They're simple to follow. They have all the information that you need. You fill out the information and you submit it to the court. And again, going back to the family court, remember what I said initially, it was the family court that reached out and said that they were going to be the court to handle these. And they are the ones that have produced these documents. So I recommend that you use them. When can you file? Well, you can obtain the order prior to the birth, and we recommend that you do that. And what happens is this judgment of parentage can be issued prior to the birth, but does not become effective until the birth of the child. So what happens is you should file before so that you have the order in effect when the child is born. Once the child is born, the intended parents are now the legal parents of the child, and you have your order to go forward. The ramifications of that are for another seminar about the new parentage and new families and what it means now for these new parents in their obligations with each other. But that's for a different time. But it's the petition that gets filed, it's in the court, you obtain your judgment or your order of parentage, and you have what you need to go forward. Okay, I think at this point, Joe Milizio will like to talk about some of the agreements and what's necessary to be included in an agreement. So I'll turn it over to Joe.
Yeah, there's always that. Sorry. Joe, thank you very much. Very informative. One thing that I do want to mention as far as the judgments of parentage are concerned, and I saw there was also a question in the chat, so I'll address it hopefully for the person asking the question as well, is that we used to use adoptions, second parent adoptions, for the most part to certify, obviously, parentage for both of the parents. And the question in the chat was, gee, do lesbian couples who are married and who are listed as the parents on the child's birth certificate still have to go through an adoption process? And we traditionally have given the advice that yes, you should go through the adoption process because a birth certificate is only a presumption of parentage. It doesn't mean that the parties are specifically the legal parents of the child. It's a presumption which can be overturned. So the new law now allows, as Joe indicated, a judgment of parentage even before the child is born, which would alleviate the need to go through a second parent adoption, except of course if the child is already born or is the child of one of the parents, and let's say a partner of the biological parent would like to adopt the child as well, then a second parent adoption would be necessary in similar circumstances. But for a married couple who do have the parentage on the child's birth certificate, we would still suggest that they proceed with an order directed by the court that states that they are the legal parents in order to overcome that presumption. And it would obviously be an effective order no matter where the child might live or be brought, so that no jurisdictions either within or outside the United States can question that parentage. That being said, let's turn back to the surrogacy law in New York and what is allowed and not allowed. So you'll recall that Dr. Goldman mentioned two types of surrogacy, gestational and traditional or genetic surrogacy. The traditional or genetic surrogacy arrangements are, I guess, what would be referred to as traditional, in that there is a process whereby the surrogate is actually the genetic mother or parent of the child and has a genetic relationship to the child. Those surrogacy arrangements are still not authorized in New York. They're still prohibited in New York, probably because of still concerns with respect to the Baby M case. They don't want a biological surrogate to have the opportunity, let's say, to say, this is my child and I am no longer willing to give up my parental rights. So we're really dealing in New York with gestational surrogacy, and gestational surrogacy, to repeat what Dr. Goldman said, is the process by which a fertilized embryo is implanted in the gestational carrier. So the carrier bears absolutely no genetic relationship to the child. What is that process? Well, first and foremost, intended parents have to find a surrogate. Surrogates have to find intended parents, and they have to sort of agree on basics. And that's generally done through a surrogacy program, and surrogacy programs are now authorized and licensed in New York State. So generally, either side, the surrogate or the intended parents, would consult with and retain the services of a surrogacy program to facilitate the match, to facilitate the understanding between the parties, to facilitate the entire process. But once that match is made, then it's absolutely required to have a surrogacy agreement in place. And I would venture that New York is probably the most compensating as far as providing for the surrogate is concerned. Other states will allow the parties to negotiate an agreement based upon the negotiation process and what each party is comfortable with, whereas New York has very specific requirements. But in general, before we get to those specific requirements, what does a surrogacy agreement provide for? Well, it's generally a contract between the gestational carrier and her spouse if married, because again, there's a presumption of parentage. So if somebody is carrying a child, the presumption is that that child is that person's biological child and the biological child of her husband. So you have to have the husband of the surrogate sign off on the surrogacy agreement. And it basically, the agreement itself basically states that the entire process, the medical appointments, the healthcare providers that will be utilized, the agreement, of course, by the surrogate to relinquish any parental or rights to the child after birth. The intended parents' responsibilities are financial obligations to a very large extent. We'll go through that in a little bit more detail on a summary in a minute, but it also outlines, the agreement itself outlines the risks and the liabilities that there might be in going through such a process, such as cesarean sections, miscarriages, potential abortions, illness as a result of the pregnancy, things along those lines. It includes information on, again, what clinics will be used, whether or not the surrogate has to be celibate for a period of time before the pregnancy, and if so, for how long. It's usually a 2-week period before the implantation process. The agreement would provide for generalizations such as confidentiality provisions so that the world does not become aware of the process and the child that resulted from the surrogacy arrangement. And it can include such things as breast milk usage and a fee for or payable to the surrogate for supplying breast milk. But the very specific requirements of a surrogacy agreement in New York are that the parties have to be at least that the surrogate has to be at least 21 years of age, either a US citizen or a permanent resident. for at least 6 months. The surrogate has to go through a medical evaluation with respect to the anticipated pregnancy. The surrogate has to give informed consent to the surrogacy after being fully advised of the medical and psychological risks. They are entitled to an independent attorney of their choosing, which is paid for by the intended parents. They are entitled to a comprehensive health care policy, which is also paid for by the intended parents, and the health care policy has to remain in effect for 12 months after the birth or the termination of the pregnancy. From the intended parent's perspective, at least one of those parents, if there are more than one, has to be a U.S. citizen or a permanent resident for at least 6 months. The intended parents also have to be represented by legal counsel who will advise them on their rights and responsibilities. Now, who can the intended parents be? The intended parents can be a married couple. They can be an unmarried couple. They can be a married couple who are separated, but without the consent of the other spouse. The separation must be for a duration of at least 3 years prior to the surrogacy arrangement. And of course, the intended parent can be a single person. New York also requires the use of an escrow agent, a licensed escrow agent, whereby all funds that are going to be utilized throughout the surrogacy arrangement, so that would include healthcare costs, fees to the surrogacy program, fees to the surrogate, clothing fees, medical fees, any type of travel expenses, anything that's encompassed within the surrogacy arrangement has to be deposited with an escrow agent so that the escrow agent can make the payments to the surrogate directly, so that the intended parents never have to get involved with making those payments or having to make any type of, or attempting to make any kind of a decision with respect to whether or not those payments have to be made. The agreement also has to include information with respect to the sperm and or egg donor if they are known. If they are anonymous, the agreement should state that the donations were anonymous. It goes on, but let's just say it is very specific with respect to providing for the surrogate. The surrogate also is entitled to counseling services if she chooses, again, paid for by the intended parents. And this is all in addition to compensation paid to the surrogate for the actual surrogacy arrangement. And what the compensation is under the statute is the compensation paid based upon medical risks, physical discomfort, inconvenience, and the responsibilities that the surrogate may be undertaking in connection with the participation in the assisted reproduction. Now, in addition to that surrogacy agreement, the surrogate has to be supplied with what is referred to in the Family Court Act as the Surrogate's Bill of Rights. And the Surrogate's Bill of Rights contains even more obligations that the intended parents have to abide by, and rights that the surrogate herself has as a participating surrogate. And that would be essentially the right to control health care in all aspects. So she has the right to state who her healthcare providers will be. She has the right to state what procedures and processes she will undergo. She has the right to abort the fetus. And that means that the agreement itself has to continue even though there may be an abortion throughout the process. And what I mean by that is healthcare costs still have to be paid, and the intended parents still have to make sure that the surrogate is financially taken care of. So the Bill of Rights, together with the surrogacy agreement, are utilized in what Joe Trotti referred to previously in obtaining the judgment of parentage as part of the entire process. And I think we're about ready, if not over ready, for questions and answers.
I think Joe muted himself a little bit early, but
Did I mute myself? I was.
now we can hear you. But thank you.
It said the host muted me, so I'm blaming you, Roy.
Yeah, you blame me.
Why don't you go ahead?
So we have a bunch of questions, and we're going to try to get to all of them. I just posted in the chat everybody's contact info, all different practices that are relevant to what we talked about today, Dr. Goldman's contact info. And I invite you, I put the link to sign up for our mailing lists. If you haven't done so, you can control exactly what subjects are of interest. That way you can receive the recording of this webinar, which will also be posted to our social media and our YouTube channel, etc. You can choose exactly what you sign up for, and if you want to unsubscribe at any point, and that's all in the chat. We have a couple of questions that have to do with insurance. I'll read both of them back to back, and then we can answer. One is, my understanding is that 3 rounds of IUI must happen before insurance will cover IVF. Is this correct? And typically for an employee of Northwell covered under the value plan, how costly can fertility treatment be? And then we had another question regarding insurance further down. Will you be discussing the new 2021 New York State mandate for IUI IVF coverage for LGBT couples for folks who work at companies between 100 and 1,000 employees, specifically when health insurance companies are not implementing this new policy and denying LGBTQ couples access to fertility treatments? What next steps can a person take to receive this coverage?
So I can try to answer some of these questions. So in terms of whether some number of IUIs are required before somebody will get coverage for IVF, the short answer is it depends. Different insurance companies have different requirements, and those requirements are really dictated by the insurance companies. So there are certain insurance companies that don't require any sort of proof of infertility, any number of IUIs. And then there are other companies that require somewhere between 3 to 6 to even 12 sometimes IUIs, depending on the age of the person that has the egg, before covering other fertility treatments. And it's very much based on insurance coverage. In terms of Northwell specific coverage, and I don't want to misspeak at all, but I don't think that IUIs are required prior to initiating treatment with IVF, although it might depend on the specific plan. And there's multiple different plans even within Northwell, and they have variable coverage. Without any insurance coverage for IVF, the costs still kind of depend on the person and on the situation. Hospital costs can be about $8,000 to $10,000, and then medication costs are totally separate, go directly to drug companies, and the amount of medication that's required is really based off of what's called the ovarian reserve, which is another way of saying how many eggs a person has left in those ovaries. The more eggs that you have, the less medication is required to stimulate those ovaries to get the eggs out, and the lower the ovarian reserve, the higher amounts of medication that are needed, and that can be much more expensive. It can essentially double the cost of the IVF cycle. Northwell specifically, I don't believe that they require IUIs initially, but if there are any questions about that, then we have a whole financial team that looks into the insurance coverage for each individual and each couple that comes into the clinic to see about what's covered, what's not covered, how to make it most able from a cost perspective for everybody.
Thank you. Joe, should I move on to the next question, or would you like to add anything to that?
Nope, go ahead.
Comprehensive. So we have two other questions that are related. So I'm going to read them back to back, and this is really more for the attorneys. One is, I know a few same-sex female couples that have had to adopt their children, even if they are listed as the parents on the birth certificate. Is it recommended that a partner officially adopt a child if they did not carry that child to be seen as the legal guardian of that child in all states? You sort of answered that, but maybe it's worth returning to. A related question is, I just wanted to clarify, if a lesbian couple is having a child via donor sperm, one partner is considered the biological parent. Would that couple do a judgment of parentage or second parent adoption in this case for the parent that isn't carrying? Or two, how long before birth do you recommend starting this process? I figured you could answer all 2.5 questions at once.
Joe, I'll let you start because I think you covered, Joe, the reason that we still do second parent adoption, different states, different countries, but maybe you want to elaborate again on that.
Right. So if the child is the biological child of one parent and the second parent comes into the family at a later point, a second parent adoption would be necessary. If, however, in the scenario that Roy was just reading in the question, if one parent is pregnant with donor sperm, and the other parent obviously is not biologically related to the child, then at this point, pursuant to the new surrogacy law, they can seek that judgment of parentage anytime after the pregnancy is started. So, in sum, the judgment of parentage is probably a lot more useful for people who are in the process of having a child. The second parent adoption will be useful for children who are already a part of the family with new parents coming in.
Yeah, that's the answer. And I think a lot of this stems from the old law in New York regarding in the LGBT community, where typically the women would have, one would be the biological parent and the other obviously was not the biological parent, and they would have a relationship and then they would split, right? And they would go their separate ways. And when the non-biological parent would attempt to get visitation rights, even if they had a relationship with the child for years, prior to recent law, they didn't even have the right to have standing, their ability to bring a custody or parenting time petition to that court. And so we were definitely saying that you had to do a second parent adoption, because without a second parent adoption, without marriage and without biology, those women had no rights in the state of New York. That's changed since the Brooke B case and its progeny in the last 3 or 4 years, where now under certain requirements, they do have standing to bring it. But why take that chance? Why wait for that proceeding? Get the order of parentage, which you can do now before the child is born or after, or when are you going to do it? But you don't want to be in that position where you're just getting standing to bring the proceeding. You want to be declared a parent so that issue is moot down the road.
Now, does that change for reciprocal IVF, since one partner is biologically related, but the other partner carried and birthed the child?
Yeah, because the partner who carried the child to birth would still not be genetically related to the child.
And we have 2 more questions that seem to be more in Joe Trotti's direction. One is, speaking of marriage law, is it true that in Nassau and Suffolk, a ULC ordained person cannot officially marry a couple? Something about Section 11, by whom marriage must be solemnized. My future wife and I want to have a friend marry us who has been ordained by ULC.
I have heard of no such rule in those 2 counties. So
This is a fun fact. I have heard of this.
Oh, wow.
So yes, and maybe it's not a fun fact, but it's a fact in any event, a little known fact. And whoever asked that question, that's some good research, because yes, it is true. ULC ordained ministers, otherwise known as internet ordained ministers, are not authorized in Nassau or Suffolk County to perform marriages, meaning they are not included in the statute as representatives who can legally perform marriages. That being said, everybody obviously that gets married obtains a marriage license, and that marriage license is signed off by the minister who conducted the ceremony, and the parties themselves to the marriage will never say, gee, that minister was not really ordained, so we're really not married. Except, of course, if one party is seeking a divorce and wants to allege that the marriage never officially took place. Have I ever seen that? Not once. Has Joe Trotti ever seen it, who does divorces on a pretty consistent basis? Joe?
Not once.
Right. So I have seen people in Nassau and Suffolk counties on many an occasion be married by a ULC minister. And the answer to your question, I suppose, is yes, you are correct. It isn't authorized, but who's going to complain about it?
Right. Well, either way, mazel tov to the engaged. There's a question for both Joes from Right Options Egg Donation and Surrogacy Agency. Does New York State require any documents to be provided by an agency in order to obtain or to file for pre-birth orders?
Can you repeat that, Roy? I'm sorry.
Yes. Does New York State require any documents to be provided by an agency in order to obtain or to file for pre-birth orders?
Well, it wouldn't come from the, I assume when the reference is agency, it means the surrogacy program or an adoption agency. But the only thing that would be required would be information with respect to the donor, the sperm or the egg donor, for purposes of completing the court petition.
Yeah, agreed. That's what I think.
Okay. Yes, the person asked earlier, but the ULC ordained minister wants to be clear that they're okay to move forward with this friend.
That's a happy news. I'm usually on the divorce end, so I'm happy to hear people asking about different ways to get married. So
You
that's good.
tried the first same-sex divorce in New York, didn't you?
Correct, we did.
Any other questions? You can type it in the chat or raise your hand. Well, there's some good questions here, so. Nope, that's comprehensive. If you have any follow-up questions at any point, we would be happy to answer. The Joe's and Dr. Goldman's contact info is in the chat. I pasted it. You will also be sending out an email if you sign up for our mailing list. If not, keep an eye out. Next week, we'll post it on our social media. We're getting.
You can also reach out to us, Roy, for petitions and forms in case we can help them with that. They can reach out to us for that as well.
Right. I would also like to add one quick note, and that is once you have a child, other legal documents you may want to consider are guardianship, trusts, and in general estate planning, which is something that really should be done as soon as a child is underway. And
Roy, that's another good point that I neglected. One of the requirements of the surrogacy law and a surrogacy agreement is that the intended parents have wills in place that would provide for the child if the intended parent or parents should pass either before the child is born or obviously anytime after It is a requirement. So intended parents, as part of the surrogacy process, must have wills in place.
Thank you, everybody,
Okay.
and happy Pride. And we'll see you next webinar.
Absolutely. Dr. Goldman, thank you very much.
Thank you, Dr. Goldman.
I
Pleasure.
appreciate it. Have a good night.
Good night.